All right, you'll have to forgive rather my exuberance this morning. I've been on a high for 2 weeks because we've just had in OH&S land probably the biggest decision, certainly in my time as 12 years as an OH&S lawyer, being handed down by the High Court in relation to a prosecution of a company and an individual. Some of you might have heard or read about it. It's called Kirk Holdings. Mr. Kirk was an elderly gentleman who was sick that owned a farm. He decided to hire through his company, or rather employ through his company, a farm manager. The farm manager decided to buy an all-terrain vehicle, which is a motorbike, to undertake some fencing on the property. Now, this Mr. Kirk gave evidence that he knows nothing about motorbikes. He's old, he's sick, he just wanted to buy a farm. And what happened in that case was the farm hand, or the farm manager, went out and bought the bike. He chose it himself, read the manual. The manual said do not take it down a steep gradient. He did, and unfortunately the four-wheel drive motorbike turned and the farm hand was killed. WorkCover New South Wales prosecuted Mr. Kirk and the company for failing to instruct, adequately supervise and train the farmhand in relation to use of the motorbike. Mr. Kirk and his company came up and ran a defence before the Industrial Court of New South Wales, which is where these matters are heard, and said, you know, I've got no idea how to use this. How am I supposed to comply with the legislation when I just don't know myself? That he was downed in the Industrial Court, and they said, no, bad luck, we think you're guilty and we're going to impose a criminal conviction on you. They appealed to the Court of Criminal Appeal. They lost again. They appealed to the High Court, and a fortnight ago the High Court came down and said, no, Industrial Court, you've actually been interpreting this legislation incorrectly. It's not reasonable for somebody to be able to supervise and instruct and train the way that you say Mr. Kirk could have done, and they've actually overturned that conviction. So it's a huge decision for us, and it's very, very exciting times. Particularly behind all of this is this new Work Health and Safety Act that's going to be coming in, a national act. So we're all running around like headless chickens, very excited about that. Clearly I need a life. All right, I do a lot of these talks, and often I get people sitting back in their chair, eyes rolling back thinking, excellent, here comes a safety lawyer to talk to me about paper cuts. Well, if there's one thing that I'd like you to leave with today, it's that this legislation and this incoming bill is against a background of a criminal jurisdiction. So we're not talking about trees falling down in the neighbour's property and someone getting a tap on the wrist. We're actually talking about a court and an act that can hand down criminal convictions. If you're convicted as an individual under this legislation or the current legislation, you receive a criminal conviction, which means if you travel, you must disclose that criminal conviction. Yes, even though it's for a safety breach, because we're in the same jurisdiction as murder cases, manslaughter cases, rape and assault cases. All right, it's the same jurisdiction, same laws. And more importantly, out of the way, in New South Wales, I should point out, 96% of people that go before the court in an OH&S case lose. So WorkCover get up in about 96% of cases. Now, why I'm so excited, because I think that will change as a defence lawyer, given the Kirk decision. And we've also got this new legislation coming in that I think will change things and make things a little bit fairer as well.